Members, it's 4:30. This is the Bills Committee on Inland Revenue Amendment number 5 Bill 2018. We have a quorum now, so I call to order the meeting. Can we elect a chairman, please? Any nomination? Dennis? Mr. Kenneth Leung. Agreed. Mr. Wong Ting Kwong scrambled to second the nomination. Mr. Kenneth Leung, do you accept the nomination? Yes, I do. Any other nominations, please? No. I'll count to 3 then, since there are not many of us. 1, 2, 3. Please come over to chair the meeting. Mr. James Ho, could you stay on a bit, please? To ask questions. I think I should ask whether we should elect a deputy chairman. If not, can we invite the administration to join us? Good afternoon, government officials. This is the Bills Committee meeting on Inland Revenue Amendments number 5 Bill 2018. This is the first meeting, actually. Well, I should introduce the government team. From the Financial Services and the Treasury Bureau, Mr. Andrew Lai, Ms. Pak Fin Yong, from the Inland Revenue Department, Mr. Chiu Kwok Kit, Ms. Chen Shun Mei, and Ms. Lam Pui Kun. And on second row, we have from the Department of Justice, Ms. Ray Chen, from the Financial Services and the Treasury Bureau, Ms. Eureka Zheng, from the Hong Kong Monetary Authority, Ms. Yunak Fong, and then Mr. Wong next to him, and then from the Environment Bureau, Mr. Desmond Zhang, and also from the Electrical and Mechanical Services Department, Mr. Chen Pak Cheng. And also from the Environment Bureau, Mr. Paul Wong. So there are 3 parts to this bill. First part is on personal assessment, second part is on environmental facilities, and the third one should be about the tax deduction for qualified debt instruments. So 3 parts really to the bill. Ms. Lai, can you please take us through this bill and the relevant policy issues? Thank you, members. Well, there's a large team here at the meeting today because this bill, as you mentioned, Mr. Chairman, involves 3 different policy areas. There's taxation matters, there's environmental protection, also development of a bond market. So we want to be efficient. We don't want to come with 3 amendments to the bill. That's why we are grouping all the amendments into one bill. But then the 3 amendments share something in common. That is, we need to amend the Inland Revenue Ordinance before these measures can be put in place. And the second thing in common is that these initiatives were announced in the budget of the Financial Secretary this year. Perhaps I could take you through the 3 matters covered by the bill. First, it has to do with personal assessment. As you know, in the Inland Revenue Ordinance, there are 3 different types of tax: salaries tax, profit tax, and property tax. Personal assessment is not a form of tax, but is rather an assessment method to relieve the tax burden of taxpayers, so they end up paying less tax. If a taxpayer has more than one sources of income, for example, the taxpayer has to pay property tax as well as salaries tax, then the taxpayer could elect personal assessment to lessen his tax burden. Under the current Inland Revenue Ordinance, if it's a married couple, then both must elect for personal assessment before the IRD would entertain their request. With this amendment, we would like to relax this requirement. That is, either of the spouse may choose to or elect for personal assessment separately. So in other words, we are giving more flexibility and the option to taxpayers, either the husband or wife. They could do the calculations and they'll decide whether joint assessment is more favorable or personal assessment is more favorable. So it's for them to say. There's no need for both of them to say yes. They don't need to make the decision together before they could elect for personal assessment. So with this relaxation, of course, it's going to benefit taxpayers, because if it's not to their favor, they would not choose not to go for personal assessment. So therefore, taxpayers will welcome this initiative. Second one has to do with an energy efficiency, environmental protection installations. Under the current legislation, if businesses procure environmental protection installations, the capital expenditure could have a tax deduction in full in 1 year. As for renewable energy installations, right now the tax deduction is over 5 years. But for buildings and the power consumption, well, buildings account for 90% of power consumption in Hong Kong. And they also account for 60% of carbon emissions. We want to move towards low carbon economy, and we want to encourage businesses to use energy efficiency installations. So starting from this year of assessment, if businesses procure energy efficiency or renewable energy installations, doesn't matter if it's wind energy or solar energy or hydro energy, if they procure such installations, they could have tax deduction in 1 year instead of over 5 years. So again, that would be a measure to benefit enterprises. The third initiative has to do with tax exemption for debt. Now, since 1996, the government has introduced a qualifying debt instrument scheme. So the aim is for Hong Kong to develop into a bond center. And also this year, as you know, the government is now taking the lead to issue bonds. This year there will be green bonds issued by the government. This is to support the development of the bond market. Under the current IRO, for debt instruments issued by the Central Money Markets Unit of the Hong Kong Authority, and the tenure is more than 7 years, then there's a 100% tax exemption. If it's less than 7 years, it's 50% tax deduction for the profits. Now, the Financial Secretary has proposed in his budget 2 concessions. One, for all qualified debt instruments, regardless of the tenure, whether it's more than or less than 7 years, there will be full profits tax exemption. This will encourage the issuance of short-term bonds. Secondly, for the qualification, right now only instruments lodged with and cleared by the Central Money Markets Unit of the Hong Kong Authority, Hong Kong Monetary Authority, could be exempted. But in future, for debt instruments listed on the Stock Exchange of Hong Kong Limited will also qualify for tax exemption. So these are the 3 measures proposed in the budget. So before the announcement of the budget, we had to keep the measures confidential, so we did not conduct any consultation. But after the delivery of the budget, the FSTB has consulted the reference stakeholders and they welcome these proposals. So we hope members will support the bill. If the bill is passed by the Legislative Council, then the free taxation measures will commence in the 2018-19 year of assessment. Thank you. Perhaps I'll stop here. Mr. James Toh, I don't think we need to put a time limit. Mr. Toh first. Well, yes, just a few short questions, really. Now, I am not familiar with the history. How come in the past the couple must both elect for personal assessment before it's allowed? Is there any special reason? Well, yes, Mr. James Toh's observation is right. In the past, if it's a couple, then they must both elect personal assessment before it's allowed. Why is it that in the past there's the option is not was not given? Well, that's because if we have relaxed this requirement in terms of the computer system and the assessment procedure, there will be additional workload for IRD colleagues. Now, of course, we want the least tax liabilities or the simplest tax arrangement. So that's why we didn't give this option in the past. Sorry, your explanation is technical. You said there will be additional workload. Of course, I appreciate that. But in the past, what was the concern? Is that you know, the husband and wife pass the buck around or something? Should there be any substantial reasons, perhaps? I wouldn't say that there are convincing arguments as to why this cannot be done. No, that's not what I meant. I'm just saying that in the past, both husband and wife must elect for personal assessment. Is it because of concern about any tax loophole? Now, Mr. Chiu must be really familiar with that. Mr. Chiu? Yes, thank you. On Mr. Toh's question, perhaps I could give you some history. In the tax laws of Hong Kong, family is the taxation unit or taxable unit. About 2 decades ago, for salaries tax, that was the first to allow separate taxation. So couples could choose for joint assessment or personal assessment. But as the Secretary pointed out, personal assessment is a form of tax relief. So we did not allow couples to apply separately for personal assessment. In this bill, the amendment, yeah, it's fine. We don't need that. So in the past, it's both husband and wife making tax declaration together, and later on they're allowed to make separate tax declaration. And you know, was it just to make the change, or were there any other reasons? Because I really want to know, I'm interested rather in the history. Are there any special reasons? Well, I think the primary reason is that at the time, family was the taxable unit, and subsequently, for salaries tax, there could be separate assessment, and the personal assessment is just a form of tax relief. That's all. So you said in the past, both the husband and wife would declare tax under one single tax declaration, and eventually for salaries tax, there could be separate tax declaration. So could it be that, say, the couple has a property that's been rented out? So for one, if only one of the spouses can get personal assessment, then maybe the rental income would go to that person to pay less tax. Could that be a loophole? Well, actually, that's not really the worry we had at the time. As I explained, it's because at the beginning, family was the taxable unit.
But there was some separation at one point. Still, wasn't it the family that was used as the unit for taxation? Now, it was the salaries tax that announced separate taxation. Mr. Chiu. Yes, correct, Chairman. Salaries tax used to be subject to joint assessment. Then it was separated. PA is a kind of relief, so we didn't deal with the other taxation. Mr. To, so it was an accident of history, wasn't it? There was no worries about tax evasion, no concerns about tax evasion. Is that right, Mr. Chiu? No, there wasn't such a concern at that time. I can join the queue again. Does any other member wish to put questions? Mr. Wichiwai, I'd like to put a question here for the third scheme. Now, the debt instrument that is listed at the stock exchange that would also enjoy tax concession. So is it true that these kind of debt instruments do not enjoy any tax concession at the moment? It's only those that are lodged with and cleared by the CMU that will enjoy the concession. Now, this is extended to those that are listed. Does it mean that debt instruments that are issued by the government that fall into this category? Under what circumstances do you have debt instruments that are lodged with and cleared by the CMU? What sort of debt instruments are they? And what are the new debt instruments that are included? Now, we are extending the scope of debt instruments. Previously, they were the debt instruments recognized by the Hong Kong MA, and now we are extending this to the debt instruments listed at the stock exchange. Madam Chair, thanks very much, Mr. Wu, for the question. Mr. Wu's understanding is correct. Now, for the eligible or the QDI scheme that was in place in 1996, as long as you fulfill certain conditions, you would be entitled to tax concessions. Mr. Lai talked about the tenor of 7 years, above and below, the 100% and 50% difference. The other condition that should be met is that it has to be issued in Hong Kong. That means that it has to be lodged with and cleared by the CMU of the Hong Kong MA. Now, we have reviewed the situation. We found that internationally there are many debt instruments that are not necessarily lodged with and cleared by the CMU of the Hong Kong MA. Internationally, there are other international clearing houses that in existence. If we impose this condition to a certain extent, we will be limiting the number of debt instruments that will be traded in Hong Kong. We'd like to promote the development of the bond market, and for debt instruments that are issued in Hong Kong, other than using the CMU of the Hong Kong MA, other than benefiting the professional service providers, the debt instruments that are listed in Hong Kong Stock Exchange will also benefit the professionals. So after our review exercise, we've decided to extend or widen the scope in such a way that debt instruments that are listed at the stock exchange will also enjoy this concession. Mr. Wu, Chairman, maybe I'm not too familiar with the debt instruments in Hong Kong. I can imagine the bonds issued by the MTRC or the URA. These bonds would be lodged with and cleared by the CMU, if my understanding is correct. Under what circumstances previously would other debt instruments be lodged with and cleared by the CMU as well. Now, with this relaxation, the debt instruments that listed at the stock exchange will also benefit. Does it mean, for example, let's say a company has issued $10 billion worth of debt instruments, they may not be using the CMU, they still would be entitled to tax concessions. If this is the case, then my next question is, for these tax concessions, will the retail bonds be able to benefit from it? If a household has purchased these kind of bonds, will they also be entitled to any tax concessions in terms of profits tax? If, for example, I'm managing all of my assets in the name of company, I will be able to benefit from it. If I'm an individual, I won't be able to benefit from it. Is my understanding correct? Madam Chair? Thanks very much, Mr. Wu, for the question. Now, for these debt instruments that lodged with and cleared with the CMU, they are not necessarily issued by the government. There are local banks and foreign banks and other enterprises that have also issued these kind of debt instruments. As long as these instruments previously are lodged with and cleared by the CMU of the Hong Kong MA, their trading profits can enjoy the profits tax concession. In future, we will not limit this to the instruments that are lodged with and cleared by the CMU. Internationally, there are other clearing houses, and there are instruments that are lodged with and cleared by these international houses, but if they are issued in Hong Kong, they would still be entitled to the tax concession. As to whether an individual or a company that would be enjoying the tax concessions, now we are talking about a concession of profits tax. Normally, companies would enjoy the profits tax concession. However, under the law, if an individual has to pay profits tax, he can also enjoy the concessions as well. Mr. Wu, a further question? Mr. Kwok. I heard from the administration that family is used as a unit for tax assessment. By default, a married couple would be subject to joint assessment. If not, you have to tick the box to say that you want separate assessment, you want personal assessment. Is that right, Mr. Lai? I have to clarify this at the moment. Couples can have joint or separate assessment. I mentioned the family as a unit. That was in history. This is not happening now. This is not happening now, Mr. Kwok. In the tax return, both will have to tick the box before you would be subject to joint assessment. Right, I understand now. Mr. James To, second round. I have to ask all the standard questions as a matter of course. Now let me ask the three items one by one. For the first one, you can have the PA separately. From your projection, how many cases will stand to benefit roughly? Now take the last year of assessment. How much revenue foregone are we talking about? I don't think it's too much, but I think for the record we have to put a question here. Mr. Lai, please. Thank you, Mr. To, for the question. For salaries tax, 1.8 billion taxpayers are on the list for 1617 year of assessment. Those who apply for PA, or personal assessment, the number stands at 235,000. Now, for these 235,000, 107,000 having applied for PA didn't have to pay anything in tax. For those who have to pay, we are talking about 128,000 of this 128,000. Two-thirds, 80,000 are married couples. Some of them may choose joint assessment. Some may choose separate assessment. From history, those who have to pay tax at the number stands at a few tens of thousands. The revenue foregone, definitely there is revenue foregone because we allow flexibility for the taxpayers, and they would work out whether there will be any savings before they would opt for this scheme. As to how much savings they will be able to achieve, it would depend on individual circumstances, and I don't think we can have the estimate. Mr. To, for these tens of thousands of cases, you must have a range. You must have the data there. What is the highest number, the worst case scenario? Just to give us some ideas, a rough estimate, a rough figure. Mr. Lai. Now, for 1617 year of assessment, we have all the information there. 81,000 cases involve PA opted by the married couples. The assessable income is $3.4 billion. Mr. To, now that's the joint assessment. As a result of this relaxation, you have people opting for PA, and you don't have the estimates, do you? What it would be the individual choices on the part of the family members. Mr. To, for those who didn't opt for PA, there may be cases in which they opt for separate assessment. If they want to elect for PA or personal assessment and have benefits, enjoy benefits, then they must be entitled to more than one type of tax. If it is just a salaries tax, it would be another matter. Well, Mr. Lai, you don't have to tell me who's eligible. I'm trying to estimate, in theory, there may be more than one type of tax, and previously they may not have elected for PA, and we're not talking about tens of thousands. 81,000 have elected PA. I'm talking about those who have not elected. What Mr. To, it doesn't have to be married couple. Individual can also elect for PA if he has more than one types of income. If he has property income, if he has other profits. Now, let's say an individual has more than one types of income, he can opt for PA, and the number can be enormous. Who can take the questions? Mr. Chiu, Deputy Commissioner. Let me take the question by Mr. To. As the Deputy Secretary said, for those who opted for personal assessment, and the number is 128,000. $4.8 billion of tax revenue is involved. As Chairman said, single individual can also elect for PA. So what we have to face is the married couples. 81,000 cases opted for PA involving a sum of $3.4 billion. Now, let's say half of these married couples would stand to benefit more if they have PA, then the the revenue, tax revenue involved would be $1.7 billion. So I understand now. The second thing is environmental protection installations. The deduction within 1 year. So this is not a must. In other words, let's say if it doesn't benefit too much, if deduction takes form of 1 year deduction, then he can separate into different years. All right, Mr. Chiu. Under the ordinance, it is a deduction for 5 years. What is being proposed is the deduction can take place within 1 single year. So one would stand to benefit more because there is depreciation, so the depreciation will be brought forward. So Mr. To's understanding is correct.
So you won't allow them to artificially choose to do it in the first year. Well, you said of course they could bring forward, but what if they close the business in the first year? Maybe they get a tax deduction of 30% and then they sell on the installations to another company with profits. But anyway, now you don't allow for that, right? So either it's full deduction and they can't choose to have 30% or 40% deduction, and then there may be a residual value. You know, they have very complicated arrangements. We don't know about that. But anyway, so you just don't allow it. That's all I need to know. Okay. Commissioner? Now, one-off deduction definitely is the most beneficial to taxpayers. Yes, if they continue with the business. If taxpayers say, I choose not to do so, because the installations are part of the building, then they could still opt for the tax deduction arrangement for buildings. For the original tax deductions for buildings, the amount is small, isn't it? 4%. So it's not too bad. Well, no, that won't be an alternative option anyway. So either it's full deduction, or they can't even go back to the deduction for 5 years, right? That would be the the phased out arrangement. Okay, so it must then. Now a question on debt instruments. No, actually I should ask this question first. Why is it that initially only the debts recognized by the Hong Kong Monetary Authority could enjoy tax exemption? Why was it? Because you were concerned about supervision, or people would be doing something funny or whatever? Well, actually, there's an historic reason for that. For the design of the whole scheme is to promote the bond market in Hong Kong. And a very important infrastructure in the local bond market is the central money markets units of the Hong Kong MA. That's why at the very beginning we only allowed debt instruments cleared with in custody of the central money markets unit. So that's the initially that we wanted to limit the scope. So can I put it this way? That means in phase one, you just want to promote instruments recognized by the Hong Kong MA. You didn't want to promote other debt instruments. Is that right? Now in phase one, what we would like to promote is that as people consider issuing bonds, they will make use of the central money markets unit service of the Hong Kong MA. So we want more people to make use of the service of the central money markets units. Okay, you have done so to promote that, and how many people actually issue bonds or debt instruments as a result of this measure? Okay, now we have this tax exemption, but how many more instruments were lodged with the CMU. Now, as Mr. To said, it depends on how many debt instruments qualify. Now, in the CMU of the Hong Kong A, that's one factor, but we also need to look at the credit rating and the size of the issuance and so on. But one figure could be quoted for your reference. For debt instruments lodged with and cleared by the CMU, that's about 1,700. Now I'm saying that after you have offered profits tax exemption, were there more debt instruments lodged? Now we don't have any figures to compare the number before and after the initiative, but rather we could say that there are now 163 qualified instruments, and all the 163 instruments are lodged with and cleared by the CMU of the Hong Kong MA. Okay, if it doesn't take too much time, please find the figures for me. That is after offering tax exemption and before that, how many debt instruments were there? Just give us a snapshot of the situation. Okay, now for debt instruments listed in the stock exchange, the number will be far more, is that right? For qualified debt instruments, well, there are a series of criteria. Listing is just one of the criteria. For debt instruments listed on the stock exchange, there are now about 1,000. Qualified? You mentioned qualified, how many? Now, we started counting from the 1st of April 2018. But you already have a number of criteria. So for that 1,000 debt instruments, you have the data, so you should more or less have an idea. Because the next question is, of course, about the amount of foregone revenue. So you need to have an idea. Otherwise, how do you work out the foregone revenue? Ms. Cheung? Yeah, for foregone revenue, there's a rough estimate. It's really rough, though. In 2018 to 19, we estimate foregone revenue of $73 million. $73 million in profits tax. That's a lot. Okay. And the number of instruments, you don't know yet how many of the 1,000 debt instruments are eligible. Now, for the $73 million is based on the number of qualified debt instruments available at the moment. That is, instead of 50%, there will be 100% profits tax exemption. And let's say they will get listed on the stock exchange, so arrive at an estimate of $73 million. But we must stress that it is foregone revenue as a result of profits tax exemption. But if there are more bonds being issued in Hong Kong, that will be other economic gains. For example, banks or issuers will get more business, and such gains may, of course, make up for part of the foregone revenue, but then obviously we won't be able to do an estimate. Yes, I know what you want to promote, but my point is, can there be, a ballpark from your records? Let's say you estimate or you project that because of the new arrangement there will be reduction of profits tax, and as a result there may be so many more debt instruments being listed or issued. So shouldn't you have some sort of estimation? Or do you want to leave it open, and then maybe a few years later you tell us how many debt instruments there are, or whether it's $73 million foregone? I don't know. At the end, you may stand to lose, or you may say, no, don't worry. Let's say we have companies holding these debt instruments. Even if we lose out in $1 million in profits tax, then there are so many more debt instruments issued, and so many holding these instruments. Definitely, we will gain because jobs will be created. So because you're very good at such calculations, with tunnels or bridges or XRL, you are good at estimating the benefits, the economic benefits. So I don't see why you can't do it here. But this is not Bills Committee on XRL. But anyway, it's about the cost benefits. You say you're going to forego $73 million in tax revenue, but what are the gains? What are the benefits? I'm sure you'll be able to estimate that. Any rough estimate? Or you could undertake to report maybe after a year or 2 years to the panel on financial affairs as to how many more debt instruments there are. Can you do that? Well, it is true there will be difficulties in doing the estimates by the FSTB colleagues. Not that we don't want to do it, but the government is doing several things in promoting the bond market or developing bond markets. The government is also taking lead to issue green bonds, and then we encourage mainland institutions to come to Hong Kong to issue green bonds, and there are other measures to promote the bond market. So it's hard to say which of these measures pay off. Maybe the policy will end up, developing the bond market, or maybe not. But at least you should tell us. It's the same when there's the abolition of estate duty, and you said you wanted to develop Hong Kong into an asset center. I didn't do the calculations with you, but I thought that we might gauge from that measure. So even if you reduce tax and there's tax plan and so on, but every year I think that's the estate duty amounted to about $1 billion or so each year. But then we said we don't want it, or Henry Tang said he didn't want it. But do we get something in exchange? That's the thing. Because there are people in the committee who really care about these. You're trying to benefit the rich. How come you won't collect estate duty when you could? Maybe for some with tax planning it doesn't work out, but they will be taxed. Especially now property prices have gone up so much, you wouldn't even know how much a tax as a duty revenue you've foregone. But if you say you don't want it, you don't need it, you have to at least give reason. Because someone really smart and completely may work it out. And then these are voters too. I'm a voter too. So we need to have this guess element for everything, and then we'll see whether it's worth it, and we need to make the judgment then. But at least you need to give us some of the baseline figures. There's several initiatives together. For instance, what's your guess of how they will benefit us? Otherwise, you say that the formula is that we believe, and that's it. Now, even if you can't do the estimate now, it's fine. Maybe later you could do so with hindsight. Just tell us, then it's fine. That's why Mr. Kenneth Leung is being very helpful. He's really good to you. He suggested that you make any reports. If you wouldn't even do that, then you put us in a difficult position. Thank you, Chairman. Thank you, Mr. James. So we're more than happy to report a year later how many qualified debt instruments created because of this new tax relief measure. But for reference, as at the 31st of March 2018, there are now 163 qualified debt instruments. And as Mr. Lai pointed out, how many of these how many debt instruments will be issued in Hong Kong? Well, it depends on the multiple of factors. And it depends on the interest rate trend, and also what other vehicles or investment vehicles are to compete for the same customers, for instance. So that's why it's hard for us to guess how this relief measure would bring in more debt instruments. But after a year, we'll be happy to report on that.
Mr. To, the other angle is that the asset management centers, the fund, you're competing for the market, maybe Singapore or whatever. They also have offered the concession, and this would cancel out the possibilities we have here. If at this bills committee, I hope that this is not something that the top secretary woke up to promote this. I hope this is not the case. Obviously, there must be competition in the international market. So can you tell us the basis why you came up with this idea? Now, there will be revenue forgone. As legislator, I can't say it's a good thing to have revenue forgone. I won't be rooting for this unless you give us more data. Is it an international trend, or is it the case that somebody told you that they wouldn't be having a presence in Hong Kong unless you have these concessions? It would help me a great deal. Singapore, in terms of the bond market, I think we're not comparing like with like. If you look at the tax concessions in Singapore, do you have any information in this regard? Chairman, I'm done with my questions. You are from the administration. I am on this side of the table. I wouldn't say that I support any revenue forgone. I would press you for more information. I would press you for more justification. Lay all the cards on the table. Give us all the justifications. In spite of the millions of dollars forgone, I would have something to go by. I have some justification to go by instead of just pressing a button to pass this into law. Because if I encounter an erudite voter, I would be tongue-tied unless you give me more information in this regard. Mr. To is seeking more information. I think I can quantify that. Now, take this QDI scheme. I think it was 1998 or 96 that it commenced. Do you have any data regarding the number of debt instruments back then? How many debt instruments in 1996 and post 1996? What was the trend since? Let us have more information historically. If historically you can see that with the reduction of profits tax, you have the debt instruments are trending up. And if based on the historical trend, you come up with this pattern for us, it would be good. And also, each year you would make available some papers bringing us up to date about the debt instruments in the market. Mr. To, I hope you understand that historically, I could have chosen not to come here because it is very straightforward. Now, you said that the tax base is very narrow and you want a more comprehensive tax base, and you're giving up on this or that kind of sources of taxation. And then you've toyed with the idea of GST, the consumption tax. The taxpayers are saying that you're giving up on so many different sources of taxation. Of course, the sales tax would be more stable with regard to this tax. I don't think they would be avoiding these kind of tax because they would find themselves liable to custodial sentence, and they would be subject to millions and millions of taxation. It is pretty stable. And if you say that you're giving up on this, if you have other sources of taxation, and many middle-class people would be able to lend jobs, I'm not sure whether this trend is true or not. I mean, this is pent up inside me for a long time, and I just like to let you know that as an experienced lawmaker, I do have these kind of doubts. I've voted in favor of all these proposals for so many years, but every time I thought, is it really for real? I didn't push you for an update. I mean, if you have given us an update, and if your projection is so accurate, and if you can get to grips with the trend, then I can rest my case. But I mean, I have to put more questions, just in case I come across some erudite voters in my constituency. Mr. Lai? I agree with Mr. To from the finance and management point of view. We may not implement all kinds of tax concessions. We have to have our assessment. In this exercise, it would promote the development of the bond market in Hong Kong. And like Chairman and Mr. To said, our competitors in the region are posing competition. If we do not carry out these concessions, we might undermine our competitiveness. So with these tax concessions, it's going to be standing Hong Kong in good stead. It would buttress Hong Kong's position as an international financial center, and also for profits tax, and also for the utilization of professional service, it would help. As regards the revenue forgone, in the past financial year, the profits tax was $140 billion. With these concessions, we're going to lose $70 million per annum. So we have to work out how much loss we are talking about. After the meeting, we will try to elaborate the justifications for that, for this in greater detail. And the QDI scheme has been in place for about 2 decades. If we do have any data that can be shared with members, we'll be only delighted to do so. As to the benefits arising from this, like Madam Zhang said, sometime after the implementation, we are only delighted to bring the FA panel up to date about the situation. I hope that will address Mr. To's concerns. Mr. To, any further questions? No? Right, it's my turn to put questions now. I think as a matter of routine, I have to put certain questions. Some members raised the historical background regarding the personal assessment. It started off having the family as a unit. Is it not so much an accident of history? Is it because of the cultural reason that led to the development? I think Mr. To would buy this argument more. Maybe Mr. To, you're fed up with the explanation. Let me put this to the administration regarding the QDI scheme. This concessions, once implemented, all the profits income would have the tax waived, or will any companies have to pay 50%? Well, Chairman, if the debt instruments are eligible, then there will be no taxation imposed. When the debt instruments are sold, I understand that this would become capital income, and there will be no tax before. Now, still there will be no taxation. Is that right? Chairman, you're correct. If this is a move to raise capital, that would become a debt capital. Under these circumstances, is it the case that all taxpayers will enjoy the same concessions? Banks or ordinary companies or individuals? What about banks? Will they be treated differently? Mr. Chair, these debt instruments we have transaction-based arrangement. As long as the debt instruments are eligible, then you will enjoy the benefits. It doesn't change with the status of the taxpayers. The other thing I'd like to ask is the environmental protection installations. Now, one can claim tax deduction in 1 year. What about the construction, the cost? The deduction will only be allowed if the cost is paid after 2018. But, Chairman, there is a transitional period. Part of the deduction might have taken place on the 1st of April 2018. They can claim the deduction for the rest of the expenditure. I'm done with my questions. From Mr. Lai, I learned that these 3 measures come out of the budget of the Financial Secretary. So I don't think there has been any consultation that was held in public, although there was a bit of consultation. What is the response from the market out there? At the taxation liaison group, I gather that you must have had a word with the stakeholders. What do you have, what you have not? I'd like to hear from you about the reaction from the public as well as the taxation liaison group. Mr. Lai, for these 3 measures, to allow husband and wife the option of electing PA separately, I don't think anybody would raise any objection at all, because we are offering the choice that is all available to them at the moment. They will be able to exercise their options. There will not be any opportunity cost there. I'm sure that this will meet with all-round support. Who will benefit from this would depend on circumstances. Well, I am concerned that the members of the public may not be all well up in this. The taxpayers would just fill out the tax returns. Now, this concession may bring them benefits. I'm not sure whether the IRD will make available any information on the web, or to give this scheme a bit of advertisement. Yes, on our website we will be updating the details. If I may add, Chairman, the IRD is in the process of amending or revising the tax returns. We have to finalize this by November, and there is a taxation group that will be vetting the details before we put this to print. Also, the IRD is revising the guidelines regarding the personal assessment.
Any other response? Well, this is a public document. So at the tax liaison group, there has not yet been a discussion. There will be a meeting coming up. We'll see if group members have any particular views. But as the Deputy Secretary said, this is really just a tax relief measure. We don't expect any opposition. Well, I don't see the need for consultation. There are no members here, so I can't consult members. But I really don't see the need to invite views or call a public hearing. The Bureau has submitted a list of professional bodies to the Bills Committee. I'll take a look, and I'll also seek the views of other members. Then perhaps for professional bodies and stakeholders, they could give us some written submissions or response. So we'll just collect views in writing, and then we'll see what the public think about these three proposals. Or maybe they want to do more next year. They want more deduction, for instance. So this will be a channel for us to collect their views. So we will write to the organizations then. I think this is actually a good time to start clause-by-clause scrutiny. Can we bring in some more members first?
唔該晒。嗱
Thank you. So we'll proceed to clause-by-clause scrutiny. The marked up copy in English and Chinese versions are available, and the page numbers correspond on the two versions. So let's refer to the English version, but if you wish to refer to the Chinese version as well, the page numbers are identical. So from page 1 to page 55, the pagination is the same. Now let's see. To be realistic, there's no way this bill could receive its third reading within this session. But I would like to start with clause-by-clause scrutiny, and I will see if there are views from professional bodies or the general or the public. We may need another meeting anyhow to finish consideration of this bill. Will the Deputy Secretary take us through the marked up copy? For personal assessment, that's actually rather complicated. Perhaps we go through that part slowly. Let's see if we could just cover personal assessment today. Maybe we couldn't even finish, but let's get started. Thank you. I will no longer talk about the object of the bill because there are three proposals really. Let me go to the first proposal, starting from page 0001 of the marked up copy. For the reference provisions on personal assessment, they are in different places in the IRO. So individual married couples could also elect for personal assessment who need to amend different parts of the IRO. First, 19C, profits loss and profits tax, and in the case of loss, and if that's the case, then couples could not elect for personal assessment. Sorry, Deputy Secretary, could you start from the long title? Okay, yes, let me talk about the long title. For the Inland Revenue Amendment number 5 bill, it seeks to provide for the option for married persons to elect for a personal assessment separately. That's the first object. The second object is to accelerate tax deductions for capital expenditure incurred in relation to environmental protection installations. And the third object is to provide for tax exemption to cover certain debt instruments on or after the 1st of 2018. Now, may I go to page 001 of the marked up copy, section 90C. That's about a loss in relation to profits tax. 19C1B states that couples may not elect for personal assessment. That is, if individuals have not elected for personal assessment, or the individual or the spouse have not jointly elected for personal assessment, then it's not allowed. So 0002, page 0002, again, in the case of a partnership, it addresses the laws of a partnership. It says here the laws has to be dealt with under Part 7. For the triangle, A is just about individual, B is about the couple jointly electing for personal assessment. Next, page 0004, there's no amendment. Page 0005, there's some short amendment, because in B2 it states that the income must be aggregated, but there's no longer such a concept. A simple concept is adopted that is under Part 7. Can I ask a question? Now, couples may elect for personal assessment separately in future. What about joint owned properties, for instance? do you then have to apportion the shares to the couples? If it's joint tenant, do you just consider regard it as 50% each share or what? Well, we look at the income and to whom the income is vested. If it's a joint tenant property, yes, the apportioning would be 50% each. Any questions on this, please, members? No? Deputy Secretary, please continue. Next, page 007 of the marked up copy, married person's allowance. At the moment, if a spouse has no accessible income or no salaries, or the spouse or the person and the spouse, unless they have elected for joint assessment. So in the triangle, we say that for married person's allowance, if the person is married during the year of assessment, and then there are different conditions. That is, a person's spouse did not have accessible income and has not elected for personal assessment. And for B2, it says here, the person and the spouse have jointly elected for joint assessment. Other than that, they could be entitled to the married person's allowance. For 1, if the spouse has no income at all, and if they elect for personal assessment, could the person still take the benefit from the full married person's allowance? Yes, the taxpayer may enjoy the married person's allowance if the person is married during the year of assessment. That is first condition. Second condition is that the person's spouse does not have any accessible income, and also the person's spouse has not elected for personal assessment. But even if the spouse elects for personal assessment, the spouse may still have no income. Well, but maybe no salaries income, but maybe rental income or other income. Now my question is, after you've applied for personal assessment, of course there may be different types of income on your tax return, but maybe one day you have no salaries, you may not even have any, may not even need to pay profit tax because you make a loss. So maybe for a few years you have no income whatsoever. Doesn't matter whether it's a salary or profits. So for those few years, would you consider the election of personal assessment invalid, or do you wait till the person again has income? Maybe in 2015, 2016, the business fails, and or someone is fired, so there's no income, and so in 2015-16 there's no income, and then the personal assessment doesn't apply because there's no income, and then later, perhaps in 2016-17 again, the person has income. Would the person have to elect again for personal assessment? Now, personal assessment is looked at year by year. So, in other words, you have to elect every year for personal assessment. Okay, that's clear then. The square then on page 007. A married person's allowance is to be granted if their marriage subsists during the year of assessment and they have jointly elected to be personally assessed under Part 7. Okay, got it. Page 0008.
That's about the child allowance. 31.3 provides for salaries tax. PA is about separate assessment, so Part 7 has to be included. 0009, disabled dependent allowance. Again, we incorporate Part 7 into it. Let me put this to you. If a married couple elect for a PA separately, would the child allowance or disabled dependent allowance be split 50-50, or can there be different percentages allotted to either spouse? Chairman, for a married couple, the child allowance will be applied for by either party. There will not be an allocation with that. No, this is not possible under the law. Please. Moving on, page 0010. There's election for personal assessment. 1 and 1A will be amended, and we add we delete 1 and 1A and add 1A and 1B. An individual who is of or above the age of 18 or is under the age of 18 if both parents are dead, and who is either ordinarily resident in Hong Kong or temporary resident, may elect for PA on the individual's total income in accordance with this part. 1A, if an individual is married and not living apart, and both have income accessible under this ordinance, and either one or both are eligible to make an election under subsection 1, they may jointly make an election for personal assessment. So they can apply individually or they can apply jointly for PA. 1B, if an individual or the individual spouse is chargeable to salaries tax under section 10, bracket 3, the individual may not make an election for personal assessment unless the individual and the spouse jointly make an election under subsection 1A. Legal advisor, you've got some questions? Thank you, Chairman. Regarding the legislative intent and operation of the bill, I hope that there will be further elaboration. Now, under the long title, assessment in accordance with PA, the idea is to provide an option for married persons to elect for personal assessment separately for all years of assessment commencing on or after 1st of April 2018. Now, regarding Section 41, I'd like to put this for clarification. If I am a married individual, then under bracket 1, purely under bracket 1, I will be entitled to personal assessment. Is that correct? As long as I fulfill bracket 1A and B, I will be entitled to PA. Well, the legal advisor's understanding is correct. Please. All of them fall into the same provision. Let's have a look at the presentation of the provision. If you read both the Chinese and English version, bracket 1 says that an individual who fulfills 1A and 1B, then he or she may elect for PA on the individual's total income. 1A, an individual who is married, and B and C, both of them have income accessible under this ordinance, and C, either one of them is eligible to make an election under this section. Maybe it doesn't fulfill some of the conditions under 1A. The way it is presented in 1A, would members get the feeling that if I am single, then I would fall within 1, bracket 1. If I'm married, then I will fall within 1A. And then I see what I fulfill, 1A, A, B, and C, and then decide whether me and my spouse will elect for personal assessment. Since the long title is sufficiently clear, electing for personal assessment separately under the long title, if this concept is embedded into the provision just as clearly, then the taxpayers would have a better understanding that under circumstances they can make the election separately. Under 1A, if I am married, if I fulfill A, B, and C, then I can make joint election for personal assessment. So will members consider this clarification, and we'll write to the administration to see whether they are prepared to make it more straightforward to embed this concept of separate election of PA. Mr. Lai? Regarding personal assessment, we are not going to change anything. The only difference is that we allow married couples an added option of electing for personal assessment separately. For the other provisions, we're not prepared to make any modification except to say that we're trying to incorporate this additional option to make the ordinance more focused and more straightforward.
即係好直接睇到。
如果佢係未婚嘅個人，佢就會睇一；如果佢係一個結咗婚嘅人，可能佢直接跳咗去睇一笪嘢，因為未必會知道原來我能夠依然憑藉住一就已經足夠去獲得我嗰個嘅個入息，所以儘管我係一結咗婚嘅。
The drafter may wish to have a look at this. Perhaps you may wish to explain to us the logic of this way of drafting. Our legal advisor has her own interpretation. Maybe not everyone would have the same interpretation, but at least some reader of the bill might get the same feeling of our legal advisor. So our law draftsman might wish to explain to us further the way it is drafted for 41. Chairman, thanks very much, Evelyn. As the DS said, 41.1, we're not going to make any substantial changes. We're not limiting this to married or unmarried individuals. We're basically talking about an individual. In the original section 41, it is subject to subsection 1A, and for subsection 1A, the spouse has to make the same election for personal assessment to be undertaken. So in this section 41.1, we don't impose any limitation. We don't bundle this together with any other provisions. It's just that in 1A, we are putting forward another situation in 1A, A, B, and C. If one fulfills these conditions, then they may jointly make an election for personal assessment. So in 1 and 1A, they are not exclusive per se. So the choices are not exclusive per se. Thank you. I've read so many pieces of legislation myself. As a legislator, maybe some would have some misunderstanding. The way it is presented, one is an overriding provision, and 1A is branching off from bracket 1. I find your explanation satisfactory to the general reader of the bill. Legal advisor, any further points regarding Section 41? The other one is more like an operational matter. Would you speak up a little bit, please? By virtue of 41, there is a situation where a married couple, one spouse is eligible, the other is not, and by virtue of this new provision, they will be able to enjoy the personal assessment. Will the administration tell us about the basis of tax assessment? Is it the same as 41A, and with the inclusion of this 1B, it will not make a difference to the situation? We have written to the administration on this very point, and they will, I hope, explain further to the Council. Chairman, under the personal assessment mechanism, nothing has been changed. Thank you. Any further questions? If not, will the Commissioner please carry on? 0011, page 0011, the triangle there, we've added a new provision. The reason for doing so is that the ordinance doesn't give people the power to give up on their right. Now here we are conferring upon them this right. In 3A, an election made by an individual may be withdrawn by the individual. An election made by the couple will have to be withdrawn together. And 3D or 3B, a withdrawal must be effected by giving notice in writing within 6 months after the date on which a personal assessment is issued, and within another period that the Commissioner considers reasonable. 3C, an election withdrawn is to be regarded as not having been made. 3D, an individual who has withdrawn an election may not make an election again for that year of assessment unless the Commissioner considers it appropriate to do so. Any questions? Please. Thank you, Chairman. Page 0012, no revision, no 0013, 0014. Let's move on to page 0015. Basically, section 42.6 is rephrased, and we're not changing anything in the provision. Simply put, if an individual has income assessable under this ordinance for a year of assessment, the individual spouse doesn't have income assessable under the ordinance for that year of assessment, but an amount of loss is carried forward from a previous year of assessment to that year of assessment. Then, under these circumstances, the individual and the spouse would have been able to jointly make an election for personal assessment had the spouse had income assessable under this ordinance. No change? Why do you need to draft like this? To make it clearer. I agree. Yes, please.
Next, page 0016. Two A, 2B, and 2C are deleted. It's to do with Part 7, personal assessment. There's no need for these provisions anymore. 00181920, no amendments. 0021, section 59. There are some amendments here. 59, 1B and 1C are amended. It's mostly to delete the wordings, text, the individual and spouse, the triangle, 1B, the new 1B. Let's take a look at that. Subsection 1. If an assessor is satisfied that an individual carries on a trade and applies for personal assessment, the income does not exceed the tax allowance of the individual. At the same time, the individual does not have any other forms of income, then the assessor needs not assess the profits tax. In other words, if an individual has only profit income without any other types of income, but the income is lower than the personal tax allowance, in that case the assessor does not need to assess the profits tax, and that's all. 1C, again, there's no need to consider subsection 1, that is, if an assessor is satisfied that an individual carries on a trade and again elects for personal assessment, and then this individual has no other income in the year of assessment. Now, when all the allowances under Part 5 are taken into account, and the individual carries on a business solely, and he or she applies for a personal assessment, or if the individual carries on a trade or business jointly with another person, then the individual elects for personal assessment, and if that's the case, there's no need to pay tax, and again the assessor doesn't need to make an assessment. So these are just administrative measures. In other words, the profits of the individual are minimal, and the tax then the tax minimum will have to be refunded, and it would be a waste of administrative resources. So that's why we're proposing here that if the person is supposed to pay profits tax of if because of the personal tax allowance, there's no need to do so, then the assessor doesn't need to give issue a tax demand note. That's all it means. So you're just rewriting the provisions, but there's no change to the actual content, right? Yes, these are existing sections. Okay, if there are no other questions, let's move on. 0022 1D. It says that 1E applies, and 1E says that the assessor may annul the assessment, or in the case of a partnership, to reduce the assessment to in relation to the share of profits. So what it means is that if an assessor has already made a profits tax assessment for an individual in a particular year of assessment, and then the assessor believes that 1A, B, or C just mentioned apply, that means even though the assessor has issued tax assessment, it could be annulled. Okay. 0023, no amendments. 0024 is just to add another reference, 59, section 59, that's all. Now 0025, environmental protection installations. Yes, please continue. Paragraph 3, the existing provision is amended to add the year of assessment commencing on or before the 1st of April 27. So that means for 16I3, it no longer applies to years of tax assessment after the 1st of April 2018. And then 3A states, 3 capital A states that if in the year of assessment of on or after the 1st of April 2018, there's been no deduction of the installation that could be deducted in the 2018-19 year of assessment. 3B, for capital expenditure incurred after the 1st of April 2018, there could be deduction in one go. As for the original paragraph 4, we are now adding 3A and 3B. Subsection 4 is about apportionment. If the relevant environmental protection installations are not entirely for generating income in Hong Kong, so this applies. Next, 0026, 16J, proceeds of sale of environmental protection facilities. Now, since there could be tax deduction for environmental protection facilities, so if EP facilities are sold and there is a receipt, then the tax must be paid again. So you mean even if you receive $1, you have to pay tax for that? Yes. And then bracket 3. Now, under the current 16 Section I, several periods are involved. 16J3 applies to 16I3. Old provision. 3A also about old installations. 4 is about apportionment. In page 0027, 3 capital A, we're adding this new section. What if there are problems with the EP installation? Now 3A is about the time period, that is the time of sale, or if the termination of business, then it starts counting from day of permanent discontinuation of the business. And the sale must not exceed the tax deduction. 0028, 3 capital A. If the cessation of business is in the earlier year of assessment, but the EP installations could only be sold in the following year of assessment, then do you count it in the previous year of assessment? Yes, correct. Okay, next page 0028, bracket 4 is about controlled transactions. We just want to make it clear, 2A, 3 or 3A. Bracket 5, again, we just want to state clearly 2, 3, and 3A. There's no change to 0029, 0038. For the title 16K, the words change to certain date. Because for EP installations, there could be many commencement dates. So it's just to clarify the meaning by changing the word. 0031. Bracket 4, we just want to state clearly 16I3 or 4, but there's no substantive change at all to the provision. 0032, environmental protection installations owned before the 1st of April 2018. So this is a transition arrangement or provision. Let's say there is a taxpayer who has a building. It was paid for before the 1st of April 2018, and it happens to be EP installations, and the owners never been given any tax deduction before, so he could apply for one-off tax deduction, but the application cannot be withdrawn. Of course, the owner could choose not to apply altogether. Page 0033, qualifying debt instruments. Before you go to part 4, can I ask if members have any questions? On part 4, qualifying debt instruments. I think every now and then, the MA or the Inland Revenue Department will announce which are qualifying debt instruments, because after the change, there's still a need to make the announcement, because I don't see any debt instruments which may not qualify. The MA and the IRD have this arrangement for any qualifying debt instruments. They will be shown in the IRD's website. Now, if it's not on the website of the IRD, that means it's not a qualifying debt instrument. No, I'm just worried that after Part 4 amendments are passed, we talk about thousands or tens of thousands of QDIs. Are you going to put them all on the list? Because apart from private companies, that is debt instruments of non-listed companies, I don't see which other debt instruments won't qualify. But in some cases, even the debt instruments of private companies may qualify. Well, yes, it's true that instruments need not be of a listed company to qualify. So as long as they're in a relevant clearing system. Of course, if it's listed company, there may be one or two preferred clearing system. But for private companies, now you remove the tenor requirement, and so any clearing system is allowed. Is that the case? No. Okay, but there's still just a few types. Say if it's a listed company, I can't remember whether the stock exchange has debt clearance or instrument clearance. Well, it's not the case that all will qualify automatically, because there are conditions to be met. First, they must be listed in the stock exchange. If they're not listed, then they must fulfill the original requirement. That is, that they must be lodged with and cleared by the CMU of the Hong Kong MA. So they have to satisfy either condition before they would qualify for this tax exemption. So in other words, the IRD will continue with the current arrangement. We'll keep in liaison with the Hong Kong MA. We'll also keep in touch with the stock exchange. And so the arrangement is for the qualifying debt instruments to be listed on our website, so people will know immediately. So you're still going to make the announcement, fine. I'm just worried that you will be, compiling a long list. That there will be more and more types. Well, that would be a good thing. Page 0033 of the marked up copy. Now, this section is just to give the commencement date of an earlier amendment to the RRO. So here we're just standardizing it for 2011. And we're adding new 1B. The concept is that of issuance. For any interest paid on any debt instrument, is to be is earned before or before or after the 1st of April 2018, or there any gain or profit on the sale or other disposal or on the redemption or maturity, then there is no need to charge profits tax. 1C. For the interest or gain of that instrument is to be received by associate, then this tax exemption will not apply, because it's actually in the existing legislation. Pages 0034, 35, no amendments. Page 0036, there are some minor amendments, but then actually is important in nature. That is, before it's only the CMU of MA, but now A2 is added, that is listed on a stock exchange, so that's a major change.
Roman letter 1, that issued, which is in its entirety lodged with the Central Money Market Unit, and 2, the instrument is listed on the stock exchange in Hong Kong. Now the question I have in mind is, will there be a tranche of debt which is listed in the stock exchange and the other tranche is not? Do you need to have the entire instrument listed in the stock exchange? There is the entirety in 1, but not so much in 2. A1 is lifted from the existing provision. This is about the debt issue. The issue, each issue is a unit. What about listed? So those that are listed will enjoy the concession. So we cover those that are listed on the stock exchange. The tranche, some of the tranches may not be listed. You don't look at these. Yes, we just look at those that are listed. Yes, thank you, Chairman. Page 0037. This is history. Now, the short-term debt instrument will become history with the passage of this. And debt instrument issued after 1st of April 2018 will be regarded as debt instrument. There will be no tenor involved. Again, those issued after 1st of April 2018 will be the same. 0038, there was the commencement implementation date at that time. 0039, we add a new clause 7. For these debt instruments, if there are losses, then it cannot be offset against the person's assessable profits. Now, if the profits, assessable profits, are not taxed, then they cannot be used to offset the person's assessable profits. 7 was there, wasn't there? Now, previously, it was a 50% concession for profits tax. So we had regard to 19C. There was a total waiver. What about 50%? How you deal with it? Chairman, if I may, under the IRO, there are certain types of profits that would enjoy 50% tax, and that would fall within the 19C, Section 19C. In the days to come, these eligible debt instruments will enjoy total concessions, total waiver. So this is just to make it clear. 19C, can you brief us on the mechanism? I'll run us through very quickly and briefly. We're going to come to 19C in just a moment. Page 0039, para 8. This is to make clarification. From the 1st of April 2018 to the day that the bill, the ordinance commences, all the definition of debt instrument will apply, so there is a bit of retroactive effect. No change on page 0040. 0041 is about the treatment of losses, concessionary trading receipts. 0042, 0043, no changes. Now 0044. At the moment, the eligible as proposed, eligible debt instruments will not be subject to tax. So we are specifying 14A, bracket 1 for concession provision. No change on page 45, 46, 49. And page 49 is to specify the commencement date of the old amendment. And long-term debt instrument, again, these will become history come the 1st of April, on the 1st of April 2018 on page 50. Chairman, I have done a walkthrough on the marked up copy for members. Any questions? Legal advisor, any comments on the Chinese version? Let's wait and see whether there are any submissions from the stakeholders and the members of the public. And we're also awaiting some information papers from the FSTB regarding the debt instrument market in 1996 and the development and evolvement since. I cannot say categorically that we don't need any more meetings now. If we need another meeting, maybe we need a brief meeting at the beginning of October. It all depends on whether we have any issues that cannot be resolved in writing, and if need be, we may need a meeting at the beginning of October. If we don't schedule any more meetings, I hope that the legal advisor will maintain communication with the administration. My thanks to all the members and government officials for being with us for this item meeting at Jan. Thank you all very much.